Hello, and thank you for joining the Law Office of Don Dennis, where I use my legal and engineering experience to help you build your business, protect your business, and continue to grow your business. I appreciate everyone for signing in and checking out this video, as today we have a very important topic. It's very interesting, and I encourage you to listen all the way until the end so that you will be knowledgeable and learn some very insightful information about an active case going on right now. If you haven't already, please make sure that you hit that like and subscribe button, and also hit that notification bell so that you'll know when new videos have been uploaded or if by chance we're going live. How much time, energy, and effort have you put into building your business? Or how much thought have you put into any type of business transaction before you signed on that dotted line? That time, that energy is irreplaceable. And if someone came and destroyed your deal, took away your business, how would you feel? There's a guy named Paul that years ago, he worked real hard throughout his life to build a family business. He used recipes from his mom and his grandmother and other aunts to create all the significant, great dishes that he had at home. He was able to share it with the world. And over time, his business gained in popularity and acclaim. And all throughout the Los Angeles area, people knew about his company and knew about his business and wanted to patronize him. And it continued to grow. And as time went on, he wanted to do the right thing. So he filed and obtained a trademark registration for his business name. And, he felt like, hey, I've done the right thing. I've taken the right legal steps. And more importantly, I'm putting out the best possible product and service that I can, because I want to be known. I want to be recognized. I want, when people hear my company's name, my restaurant's name, they know they're going to get great quality food. So years passed by, and Paul learned that there was a company, a restaurant on the East Coast in Virginia and in New York that had copied his identical business name, and they were selling the same type of food. Well, once Paul found out about this and looked it up online and verified what he had heard, he had an attorney draft a cease and desist letter. Cease and desist simply means stop and stop. They're the same words. But telling the company, look, stop selling, stop using my name and trying to galvanize and profit off of my name and my reputation, or something might happen to you. I might sue you. So Paul sent that letter off and felt like, hey, they got it. They know I mean business, and that situation is over with. Well, lo and behold, several years later, some customers came into Paul's restaurant in Los Angeles, and they said, hey, Paul, we know that you're popular. We know that you're doing good. We didn't know that you opened up another restaurant in Orange County. And Paul said, what are you talking about? I never opened up a restaurant in Orange County. So Paul looked again online and did some research. And what he found out was that same restaurant that was on the East Coast had expanded to the West Coast and now had a location in Orange County. Paul was in Los Angeles County, but now that they're in Orange County, that's getting closer and closer to his primary customer base. So he called the company up and said, look, I have a trademark. You don't have the right to use my name and my brand. I need you to stop. And the company representative at this local location in Orange County said, hey, you know what, Paul, we hear you. No problem. We'll stop. So Paul felt like, hey, I took care of it. I didn't even need an attorney this time. I could handle it on my own. Well, Paul never followed up, never took any other steps, because he had their word over the phone that everything was done and that they were going to stay off, no longer use his name. Years later, one of Paul's customers came into his restaurant in Los Angeles and said, hey, I didn't know you opened up another location. And Paul said, what are you talking about, another location? This is my only location. And they said, no, Paul, just a few miles away from here, your company's name, your restaurant's name is right outside. Everyone can see it when they drive by. Matter of fact, they have pretty much the same food that you sell. Paul couldn't believe it. He hit the roof. This company, this restaurant that was using his same name and brand moved from the East Coast to the county next to him to just a few miles from him. And then what happened? Well, what happened was people were making orders online. So his customers were getting confused because they thought they were placing orders with him. And no longer was he getting the traditional orders. They were going to the new location just a few miles away. So his traffic dried up. His walk-in customers dried up. And Paul said, enough is enough. I have to sue. So he sued them for trademark infringement. They were using his name, his logo. However, by the time he got to court, he wasn't making the money he once was. His profits had greatly diminished. And Paul couldn't even afford to pay to complete the entire trial because he filed for bankruptcy. So he couldn't even finish it. And at this time, Paul's business is out of business. This is what can happen with respect to dealing with trademarks and trademark infringement. Now, a lot of people think, a common question is, they'll just wait and things will get better, things will go away, time will heal all things. But that's not the case. Sitting around hoping and praying that things are going to get better if someone is using your brand without your permission is not protection. Having a registration with the U.S. Patent and Trademark Office is not enough as well to protect your business. In fact, let me share with you what the Patent and Trademark Office says for people that have valid registrations. From their guidebook, Basic Facts About Trademarks, it says throughout the life of your registration, meaning once you have a trademark, you must police and enforce your rights. The United States Patent and Trademark Office does not enforce your rights. It's up to you. So if you don't do it, it's not going to happen. And you can't call the police if someone steals your trademark. You can't call the police if someone steals your website or your domain name. It's all up to you. Now, today, as you can see from the title, we're talking about the Skin Plus company based out of New York and also operating out of Washington, D.C. Marcus Garvey said that Black skin is not a badge of shame, but rather a glorious symbol of greatness, of national greatness. So today we're talking about Miss Sydney Lunsford. She formed a company in August of 2018 called Beauty Concepts. And Beauty Concepts is like an esthetician company where you can go in and get salon services and facials and all of those assorted services that you need to look good. Well, she opened her first salon in October 2018, and she weathered the pandemic. A lot of businesses didn't do well in the pandemic. However, she found a way, using her creative genius, to successfully thrive through the pandemic and was able to even get a larger location in 2020. In the fall of 2021 to spring 2022, she's invested over $200,000 in her business in building out that business location. She employs 4 professionals and she's looking to double the size of her staff. In fact, her business is doing so well, she is on target to get to 1 million in revenue. That is a tremendous feat, as it said in her lawsuit against Kim Kardashian, because it's very hard for women entrepreneurs and business owners, according to various studies, to reach that kind of feat. In addition, it's also difficult for Black business women to reach that. So she is very grateful for her accomplishments. She's grateful for being able to employ others and wants to continue that great work. Well, she's applied and she did receive on March 28th, 2021, a design mark from the U.S. Patent and Trademark Office for skincare salon services and for beauty spa services and other things. Also, in June of this year, just a few weeks ago, she applied for a word mark and some other trademarks from their Patent and Trademark Office for the things that she does. Well, in July of last year, she learned that Kim Kardashian and an affiliate company called Coty, C-O-T-Y, were going to launch a new skincare line under the brand name SKKN, or Skin by Kim. Now, what's the issue? Well, the issue is Miss Sydney's business is called Skin Plus, SKKN Plus. And Kim Kardashian's business is SKKN and Skin by Kim. So it doesn't have the plus symbol. And in fact, Kim Kardashian filed for numerous trademark registrations, 19 to be exact, using the Skin by Kim name. She's looking to take over the entire spectrum of services using that name. So she filed a trademark application for beauty products, fragrance, candles, vitamins, clocks. Because when you file for your trademark registration, you have to file for each class in which you are going to be selling a product or providing a service. So, for example, if you're providing food, you might get a trademark classification registration for food, and then maybe like McDonald's, you might have shirts for clothing, for hats, for educational seminars, but you have to file that registration in each classification. So what did Sydney do when she found out about this? Well, her issue is that obviously Skin and Skin Plus, the two brands, are confusingly similar. People could easily mistake one for the other, and she could lose business. She could lose the momentum. Think about all the money she's invested. Now, obviously, it's probably nowhere near what Kim Kardashian has invested or will be invested. However, it's significant to her, and all throughout her complaint, she's emphasizing the fact of what all the obstacles she had to overcome being a Black businesswoman to get to the level of growth that she's achieved. In addition, she sent out a cease and desist letter to Kim Kardashian and let them know, look, you should not be filing this trademark because I already have a trademark. She tried to negotiate with Kim Kardashian, which is a great strategy. If you're having an issue with another business or with someone that's doing something to infringe on your business or to hurt your business, it never hurts to have a phone call with them, to try to negotiate, to try to work things out. And it's best to have an attorney represent you in that as opposed to you doing it yourself. If you have not already hit that like and subscribe button, hit that like and subscribe button, letting me know that this information is valuable and this content is helpful and useful to you. And if you need an attorney to help you with any aspect of this matter, you can always contact my office, and information is below. Now, what she has been doing, besides trying to negotiate, when that didn't work, she filed an opposition. An opposition is what you can file with the U.S. Patent and Trademark Office saying, look, someone is trying to file to get a trademark for something. I don't agree that it should be granted for this reason or that reason. In this case, it's because she's saying that the two trademarks are confusingly similar. There's a likelihood of confusion. And let's talk about what exactly what we're referring to when we're saying a likelihood of confusion, because the test for trademark infringement differs throughout the country. But in New York, where she filed the lawsuit, the two trademarks don't have to be identical. Now, in this case, they are identical. But in general, for you to be liable or found to be infringing on someone's trademark, it doesn't have to be identical. What the court looks at is what is the strength of the trademark, similarity of the trademarks, and all the things that you can see on your screen. Those are all the factors. So it's a factors test. It's not a yes or no. It's the court goes through, they look at these 8 factors, and they say, overall, let's weigh them. How many weigh in favor of someone saying that they're being infringed on? How many weigh in favor of there is no infringement? So it's a multi-factor test. Nevertheless, as the case goes to trial, that is what Miss Sydney is going to have to prove in order to show trademark infringement. Now, we talked about the fact that the U.S. Patent and Trademark Office grants your trademark, but they do not police your trademark. They are not going to go out and hunt down people that are infringing on a mark that they've granted to you. You cannot pick up the phone like you call 911 for the police and call the trademark office on a special dedicated line and say, look, so-and-so is, infringing on my mark, or they're using it without my permission. I need you to do something. That's not how it works. So you have to be cognizant of that. The game does not end just because you got a trademark. The whole time that you have the trademark, you have to enforce it. Now, we're going to see how this case unravels, because sometimes the cases can end, before trial, and other times they go all the way to trial. But it gets expensive, it gets costly, and this is what you can call a bet the business case, because depending upon how it comes out will show what may or may not happen with Miss Sydney's business. Sydney is concerned that she can easily be overshadowed by the gravity of Kim Kardashian jumping into her space, doing what she's doing. On the screen is a copy of the complaint, and it goes into detail all the work, all the effort that Sydney has taken to build up this business. If you are in a situation like this, you have to remember, you can't just sit idly. Think about the example I gave of Paul, how he just let time go by. You have to be engaged. You have to be active. You have to follow up. If you send a letter and someone is agreeing that they're no longer going to use your domain name or use your business name, you have to follow up. Get something in writing that they have stopped. And if they haven't, you have to be willing to take the next steps, which means you may have to spend money on an attorney. You may have to pay a law firm to go out and make sure things are taken care of, but it's all worth it if you feel that your business is worth it. It's a process, it's expensive. However, if you've taken the time to invest in your business, you want to follow it through all the way. I have a friend named Hosea, and he said, knowledge is having information, and wisdom is knowing when to use that information. You can spend all day reading on Google, but it doesn't make you necessarily an expert in a subject. Law students read and study 4 to 5 hours every day, even weekends in law school, but they still sit down with a professor that explains what they've read and helps them learn how to apply it as situations vary so that they can best service their clients. If you have an issue, don't rely solely on what someone has told you or just reading various articles or things online. Most of the time, you don't even necessarily know who wrote it or if what they said is accurate. Get professional assistance. Get assistance from an accomplished attorney that is willing to fight for you and be in your corner. Information from my office and how to consult with my office and contact me is below in the description. Don't hesitate to reach out and watch your business wither away like has happened to many other businesses. If your business is in the need of an attorney, contact my office. Thanks for watching. Have a great day. And leave a comment. Let me know what you think about this case or if you have any other ideas. And always hit that like and subscribe button.